Welcome back to the channel. So in the earlier video we have seen the chapter 1 and chapter 2 of the Environment Protection Act, and in this video we are moving further to the chapter 3 and chapter 4. So chapter 3 is about the prevention, control and abatement of environmental pollution. So starting with section 7. Section 7 says that the persons carrying on industry, operation or any processes shall not allow emission or discharge of environmental pollutants in excess of the standards. So who set the standard? This already we have seen in the section 3 subsection 2 clause 4, that the central government has the power to take measures with regard to these standards. So the standards have been already set by the central government, and the persons carrying on these industry and operation or it may be a process should not discharge or emit more than, that is in excess than that standard that is given in section 7. Then moving to the section 8, the persons handling hazardous substances to comply with the procedural safeguards. So it says already we have seen in the section 3 subsection 2 and clause 7 that the central government will take measures with regard to the procedures for handling hazardous substances, as well as the rules making power is with the central government under the section 6 subsection 2c. So already we have seen this. So as per that, the person should act, that is given in section 8. So the person handling the hazardous substance should comply with such procedural safeguards, it may be rules or measures. Okay, then moving on to the section 9, it says that where the discharge of any environmental pollutant is in excess of the prescribed standard. So it has already said that it should not be in excess, but if it is excess or is apprehended to occur due to any accident, so if there is a fear of any accident or other unforeseen act or event, then the person who is responsible for such discharge and the person who is in charge of that place where such environmental pollution or accident is happening, okay, so these two persons will be bound to prevent or mitigate the environmental pollution. So the first thing is that the person who is responsible for that discharge and the person who is in charge of the place has a bounden duty to prevent that pollution, and also if pollution has caused, to mitigate the pollution. Okay, and immediately, that is forthwith, they should intimate the fact of such occurrence to the authorities or agencies as may be prescribed. So authorities is already we have seen in a section, right? In section 4.5 we have seen authorities. So it should be informed to that authorities, and these persons should be bound if called upon to render all assistance. So in case the authorities or agencies wants the help of the person who is in charge of the place, he should provide his assistance, that is given. Okay, the first thing is they should do prevent and mitigate the environmental pollution, then forthwith they have to intimate the fact to the authorities or agencies, and then if in case if they need some assistance, they are bound to give that. Okay, then after that, on receipt of the information, these authorities and agencies will take all measures that is necessary to prevent and mitigate the environmental pollution. So in that process they may have incurred some expenses, right? So the expenses incurred by authority or agent with respect to remedial measures may be recovered from the person's consent, that is it may be the owner of the property or the occupier of the property, as the arrears of the land revenue or of public demand. Okay, this remedial measures has to be paid from the date when a demand for the expenses is made until it is made. So from these dates, these authorities may recover it, that is what given in this section. Then section 10. So section 10 gives the power of entry and inspection. So any person who is empowered by the central government shall have the right to enter at all reasonable time. It may be all reasonable time, okay, with such assistance as he considered necessary to any place for the purpose of, the first one is for the purpose of performing the functions of the central government entrusted to him by this act, okay. So for the purpose of performing any functions, and the second one is for the purpose of determining whether such functions are to be performed, or whether the provisions of this act or the rules made under this act or any notice, order, direction or authorization served, made, given or granted under this act is being complied with. So the authorities can enter into the place to ensure that whether this place has complied with all the rules and regulations. That is what given in subsection 1 clause B. And in the C it is given that they can enter the place for examining and testing any equipment, industrial plan or record, register, document or even material object, for conducting a search of any building in which he has the reason to believe that some offense under this act is happening, okay. And also they can seize any such equipment, industrial plan, record, register, document or other material object if he has the reason to believe that it may furnish evidence, it may act as a evidence for the commission of an offense punishable under this act, okay. Also if it is believed that if that seizure is necessary to prevent or mitigate environmental pollution. So these three powers has been given. Like the first power is entering into the place for the purpose of performing functions of central government. The second one is to ensure that every rules and regulations on the functions are being performed and complied with. And the third one is that for the purpose of examining and testing any equipment or record anything, and also for the purpose of seizure, okay. Then moving to the second subsection, it says that every person who is carrying on industry, operation or process or handling any hazardous substances is bound to render all the assistance to that person who is empowered by the central government, okay. And if in case he fails to do so, he is also guilty of an offense under this act. So this is given like punishable offense. And then if that person fails to do it, it is attracted by subsection 2. But if that person willfully delays or obstructs any person empowered by the central government, then he shall also be guilty of offense under this act. It is said in subsection 3. And the subsection 4 is, which is not necessary, but I will explain. It is said that for the provisions of the CRPC in relation to this search and seizure, in case of Jammu and Kashmir, their respective, the corresponding section will apply. That is what given, okay, nothing much. Then moving on to the section 11, it says that there is power given to the central government or any officer empowered by it to take sample and procedure to be followed in connection with. So what sample is taken is for the purpose of analysis samples of air, water, soil or other substances from any factory, premises or other place in such manner may be prescribed, right. So the power given in the section 10 is power to enter into any premises. Now 11 is like you will study it in a consequence, okay, sequence, okay. So in the section 11 it is given that you have the power to take samples for analysis. It may be the sample of air, water, soil or other substances which is from the factory, premises or other place, okay. Then in the subsection 2 it is said that the result of any analysis of sample taken as provided above shall not be admissible in evidence in any legal proceeding unless the provision of the subsection 3 and 4 are complied with. So what are the procedures to be complied with? This 3 says that the person taking the sample under subsection 1 shall serve on the occupier, on his agent or person in charge of the place a notice then and there in such form as may be prescribed of his intention to have it so analyzed. So like in the criminal offences, what in case of arrest, think that there isn't right that the person who is being arrested must be informed of the grounds on which he is arrested. Similar to that, in case some testing samples have been collected from the place, the occupier or the agent or the person in charge of that place should be given notice, like for what intention such analysis is happening, such analysis is taken. Okay, then B says that in the presence of the occupier or his agent or person should only then the authority should collect the sample for analysis. This is similar to the criminal procedure that arrest should be informed to the relatives, right? Relatives or parents. Similar to that, here it is given that in the presence of the occupier or his agent or person, collect a sample for analysis. Then it is given that cause the sample to be placed in a container or containers which shall be marked and sealed and shall be signed by both the person taking the sample and occupier or his agent or person. So the sample should be placed in more containers and should be marked and sealed, and the sample should be get signed by both the person taking it and also the occupier or the agent or the person in charge of that place. This is to make sure that only the right sample is being submitted as the evidence. Then D says that without any delay the sample should be sent to the laboratory established or recognized under the central government under section 12. That is what the next section. So this is the procedure to be followed. Only then these samples can be used as an evidence in the legal proceedings. Subsection 4, it gives some circumstances with regard to subsection 3. Okay, this first circumstance is that it is already said that if some person is taking the samples, it should be sealed, marked and get signed by both the person taking it and also the person, that is occupier or his agent or person in charge of that place. So in case if the agent, occupier or the person willfully absents himself even after the notice, what should be done? It is said that it is sufficient that it is signed by the person taking the sample alone. So this person alone can sign it and send it. Okay. The second one is that circumstances that when the occupier or his agent or person present at the time of taking sample but they refuse to sign the marked and sealed container, then also it is given that it can be signed only by the person taking the samples. That is sufficient. It is sent, it is given, and then it shall be sent without delay by the person taking it to the laboratory as provided under section 12. And in addition to that, such person should inform the government analyst appointed under section 13 in writing about this willful absence or the refusal to sign. Okay, this should be informed in writing to the government analyst. So the next section is about the laboratory provided under 12 and the government analyst provided under 13. So 12 says that the central government may by notification in the official gazette establish one or more environmental laboratories, recognize one or more laboratories or institutes as environmental laboratories to carry on this function. Okay, so they can establish it fresh, or if there is some laboratory they can recognize it as the environmental laboratories under this act. Then the central government may also make rules specifying the functions of these laboratories and the procedures for submission of the said laboratory of samples and for the analysis or test, the form the laboratory report should be and the fees which has to be paid. So these procedures the central government can make rules, and also such other matters which is necessary. Okay, then coming to the government analyze, the central government, the same manner by notification in the official gazette, may appoint or recognize such person as it thinks fit, having the prescribed qualification to be the government analyst for this purpose, to analyze the samples and send for the which is sent for the analysis to the environmental laboratory established under section 12. This is very easy. And coming to the report, section 14 says that any document purporting to be a report signed by this government analyst may be used as an evidence for the facts stated in the legal proceeding. Okay, so this is very important. 12, 13 and 14 is very important, which is about the environmental laboratories. For this, the samples are taken in accordance with section 11, and in this environmental laboratories who are appointed, the government analysts are appointed, section 13, and they will give the report and it can be used as a evidence, that is given in section 14. Clear? So the section 15 is about the penalty. We have already seen in one section that in case some person has fails to do that, he will be considered to be the person who has committed guilty under this act, right? For that, what is the punishment? If some person contravenes the provisions of this act, then the punishment is imprisonment for a term which may extend to 5 years, and also fine which may extend to 1 lakh. In case the contravention continues, then for each day 5,000 rupees will be an additional fine that is given. Okay, then also it is given a special provision that if the contravention continues beyond a year, then the conviction can be like for 7 years. Okay, then coming to section 16, these things are very similar in every act. This we have already seen in the NGT Act also. So what is given in the offences by companies means, for offence by the companies, if an offence under this act has been committed by the company, then the person who was directly in charge of or who was responsible to the company for the conduct of the business of the company plus the company itself will be deemed to be guilty of the offense. Okay, this is what 2%, like every person who is in charge of the conduct of the business of the company plus the company itself will be deemed to be guilty. And also it is given that if these persons can prove that without their knowledge or without even after his due diligence the commission of such offense happens, then he shall not be held liable. Okay, then in the section subsection 2 it is given that apart from these persons, if the offense was committed with the consent or connivance or is attributable to the neglect on the part of any director, manager, secretary or the other officer of the company, such persons, such director, manager, secretary, other officer of the company can also be deemed to commit guilt of the offense. Okay, this is what given in section 16. And in the section 17, it is always after this companies will come the government departments. So if the offense was committed by the government department, obviously the head of the department shall be held liable. And then in the provided class it is the same, it is given if the head of the department can prove that without his knowledge this has happened, or even after he exercising the due diligence to prevent the commission of the offense, this offense has happened, then he cannot be held liable. And the subsection 2 the same, if apart from these person, if the offense is committed with a consent or connivance or is attributable to any neglect on the part of any officer other than the head of the department, such person will also be deemed to be guilty of the offense. That is what given. Okay, then move on to the chapter 4, which is not so important for the UGC point of view, but remember the short titles. Okay, so the miscellaneous provisions. First, section 18, protection of action taken in good faith. So in case any person or any officer under the government or authority, agency, anything under the government take any step with a good faith in pursuance of this act, then such act cannot be sued or prosecuted, or in any legal proceedings cannot be lie against that person. That is what given in section 18, like good faith immunity is given. Then section 19 is about the cognizance of offense. These are the same thing for every act. Okay, no court shall take cognizance of any offense under this act except a complaint is made by the central government or authority or officer authorized in this behalf by that act. or even it has given the power to citizens, like citizens or any person who has given notice of not less than 60 days to the central government of his intention to make a complaint, right? So it is like a precautionary measure. So not every person come and put cases like take put complaint before the court. Only the central government or authority or officer authorized can do that, or else the person should get some permission, permission, like not less than 60 days notice to the central government, and only after that they can file a complaint. Section 20 is very simple, that the central government may require any person, officer, or central government or any authority to furnish to it some reports, written, statistics, accounts, any information. And if the central government asks for it, such person, officer, state government, or authority shall be bound to do so, and they should submit it to the central government. Then section 21 is that all the members, officers, employees of the authority constituted under the section 3 of this act are deemed to be the public servants within the meaning of section 21 of the IPC. Then 22 is about the civil court jurisdiction bar. It says that no civil court shall have the jurisdiction to entertain any suit or proceedings in respect of the environmental issues, anything done, action taken, or order or direction issued by the central government or authority in pursuance of the power conferred by or in relation to the functions under this act. So under this act, if any powers have been exercised by the central government, it shall not be challenged in the civil court. Okay, that is given in section 22. Then the power to delegate, the central government by notification in the official gazette can delegate any of its powers and functions to the states, to any officer, state government, or other authority if it deems necessary and expedient. This is so simple. Then section 24 is about the effect of other laws. In case some other act is inconsistent with the provisions of this act, and this act will prevail, that is what given. Okay, these should be concentrate very tiny, okay, not so deep. Then section 25 is powers to make rules. The central government can, in by making notification in the official gazette, can make rules for carrying out the following purposes. Like they like in illustration, these powers are given. The first power is the standards in excess of which environmental pollutants shall not be discharged, which we studied in section 7. And then the procedures like safeguards in compliance with which hazardous substances should be handled under section 8. And then the authorities or agency to which intimation of the fact of occurrence and apprehension of the occurrence of the discharge shall be given, and to whom all assistance shall be given, which is the whole scenario of section 9. And then the manner in which samples should be taken, which comes under section 11. And then the form in which notice of intention to have a sample analyzed shall be served. So how the notice, the form of the notice is in which way, that is under 11 subsection 3, that. And also the powers to the make rules related to the functions of environmental laboratories, the procedure for submission to the laboratories of samples, the fees payable with regard to all these, the government has powers. Then the qualifications of the government analyzed is also will be given by the central government. Then the manner in which notice of the offense and the intention to make a complaint, which we saw in the section 19, it should be given. And also the authority or officer to whom report, written statistic accounts, and other information shall be furnished under section 20, and also any other matter. Okay, then moving on to the section 26, very basic, which will be in every act. It says that the rules made under this act should be laid before the parliament. This is what comes under the Environmental Protection Act. There are quite important provisions, so you should study that in an orderly manner as provided under Bar Act to answer the UGC net law questions. Also, under each section, just have an idea what is given. Okay, nothing more to memorize, only the sections and the short titles. It is has to be remembered forever. Okay, thank you for watching the video. In case if you found it useful, please subscribe to the channel and give a like. Thank you.